లేదు అంత కొరికేప్పుడు
అయిపోయిందా అవ్వలేదు ఇప్పుడే చూస్తున్నాం ఇప్పుడు
హెల్మెట్ ఎత్తా చూడు, నీ హెల్మెట్ ఎత్తా.
Again start. Hello. So the all the things that you use in your daily life, please reduce the volume. So all these things are example of trademark. At breakfast, you have some cornflakes. It can be Kellogg's, then Toast of Britannia bread, Britannia, Amul, this Red and Taylor, Mobla, this mobile, maybe I don't know, maybe Samsung, and then in your car, Hyundai. So all these names, the brands and logos, these are all trademark. Somebody in the group already told you about what can be trademark. Masker, please reduce the volume. So these things are all trademarks. I'm sorry, I'm having some echo. I can hear some echo, so I'm telling some other people to reduce the volume. I'm sorry about it. Huh? No, no, some sound is coming from somewhere. Okay. And I request you guys, please don't share your screen because my screen is going off. So it takes a hell lot of time and there's no point doing all these things. Okay, please don't share your screen because my screen is going off. Okay, so hello again. What does a trademark do? Basically, it will simplify the identification of the brand or logo. So if you are going to buy one salt, you are quite aware of the Tata salt in the market and you know about the quality of the market, so you trust it. So in this case, the name Tata salt is the brand, is the trademark that guarantees the quality and the value of that product. So you use that, right? So that's what trademarks they do. So this is just a cut out from a newspaper that in Delhi there was some fake Tata salt found in factory bust and police arrested the owner. So these are about the people who are using some lower quality product, putting the same Tata salt, the packet, so that people trust it and people will go for buying the stuff. But there is something of lower quality there inside, so that's a bad thing, right? You understand? So those are bad people, they are doing it. You don't want to do like that. So these are called like cheap and inferior quality they are putting inside. So what they are gaining out of that, because they know that because of the trademark, because of the symbol, people trust that, people trust that logo, that brand, and the quality of that salt. That's why if you are putting something else in that packet also, by looking at the Tata salt trademark, people will go for buying it, right? So that is the value of a trademark, that gives the quality, that assures the quality of that product. So those are the basic utility of a trademark. This is just a simple slide that I use while uh, teaching any kind of legal subject. Please remember, I'm not sure how many of you guys are really focusing on this subject, but I can tell you, uh, because I'm coming from a science background, so when I started learning IP laws, I had some difficulties in understanding why do I need to study this. And for example, when you read the IP acts, they are really big sentences, so you don't understand what's happening. But the basic thing, if you can understand, all the legal subjects are based on logic. So if you understand the logic, you understand the subject. So you don't have to know any rocket science in that. You guys are from arts and commerce and science background, so a diverse set of background is here. But I just want to tell you something, that law is jurisdiction specific. When we study science, science is universal. So when I say science is universal, the apple, if you throw it from here, it will fall on the ground. So the gravitational force is working in India, it works in France, it works in US, it works everywhere on earth. So the science is universal. The equation E is equal to mc square is valid here, there, and everywhere, wherever science is valid. So that is the main basic law of science that is universal. So you apply the same thing everywhere. But in case of law, law is jurisdiction specific. That means that the territory where you are currently are, the law will be governed by that country's law. So when we are studying some IP law, we are studying basically the Indian IP laws. There might not be a lot of variation between all patent laws of the world, but there will be differences. There will be differences. Some certain minor differences there can be, but the thing is that laws are always governed by that country law. So law is called jurisdiction specific. So whatever intellectual property rights we are studying, the legal right, they are all territorial rights. Please remember this terminology, territorial right. That means wherever the country, wherever the application was filed, wherever the grant was obtained, it is valid in that country only. IP rights are legal rights. This is a legal subject, a law subject. I hope you guys understand. So this is the Trademarks Act in India. Trademarks Act 1999. This may come into your exam, that when the Trademarks Act came into the picture in India, that is 1999. This is an example of the cover page of that book. Trademarks means a mark capable of being represented graphically, capable of distinguishing the goods or services of one person from those of the others. Uh, that means, I always give you the same example, that if you go for buying some beverages in the market, you have Pepsi and Coke. Both of them, the color also might look similar, but the logo Pepsi and the logo Coke are very different, right? So you are able to understand, you are able to distinguish between the goods from Coke and from Pepsi. So the trademarks will give you the power to distinguish the goods between the goods or services of one person from those of another. Okay, by goods I mean all these products, and by services means, for example, Airtel is a service, that is not a product. Airtel and then BSNL or Geo, these are services, these are not product. So when they will register their trademark, they will register under services, okay, not under product. Goods and services, there are two different categories under trademark. So a trademark may include the shape of goods, also their packaging, also the way they are packaged, and combination of colors also. These are the things that a trademark can be appealed for. Section 2(1)(m) of Trademarks Act 1999, it defines the term mark. Mark includes, here in this page, you can see that trademark means a mark, right? So that mark term is defined in this book, the Trademarks Act 1999. So that's what I'm trying to explain. Section 2(1)(m) says, what is a mark? Mark includes a brand, heading, label, name, signature, word, letter, numeral, shape of the goods, packaging, or combination of colors, or any combination thereof. Whatever is written there, any combination thereof, all these things can be combination can be applied as a trademark. So here on this page you can see the Coke bottle. So the label Coca-Cola, the name is a trademark. The shape, the 3D shape of that bottle is a trademark. Please remember, if somebody asks you what is an example of 3D trademark, the bottle shape, Coca-Cola bottle shape, the 3D structure is a trademark. The whole thing is a trademark, not only the name Coca-Cola, but not the Pepsi bottle, only the Coca-Cola bottle. Please remember. Then symbol like Nike, this push symbol, MACD, this M, slogan that I'm loving it, this slogan is a trademark also. And then color, color like here it is orange, orange is a color, that is also a trademark. What is the general definition of trademark? Sign that distinguishes goods or services in a given market. I have just told you about this. Example, Pepsi for beverages, BMW for cars. These are just example. You can take any other example also. What is the rationale for protection of trademark? Trademarks protect the rights of producers and of consumers and public interest by protecting fair practices in the market. So as I said that, in that slide you can see that some people are using some inferior quality salt and putting that in the Tata salt packet. So basically that is not a fair practice. So what trademarks will do, they will maintain the fair practices in the market, so that the interest of the consumer is protected, consumer gets good quality product and things like that. So the owners of the, in the next point you can see, the owners of the trademark, they can prevent third parties from using confusingly similar trademarks for similar products or services. So when the owner gets the trademark right, what they can do is they can prevent the third parties. What kind of right they get is that they can prevent the third parties from using confusingly similar trademarks. For example, if Pepsi is always there and you just remove one of the letter and put, instead of PEPSI, you just rotate P and make it D, so that still might look very similar. So you cannot use anything very similar, that phonetically similar, or by saying it you can say it's very similar. Those kind of things you are not supposed to bring out in the same class. So in the same beverage, if you bring out Pepsi or Pepsi, things like that, that might sound very confusing. So those things are not allowed. So the person who has got the right on the trademark, they can stop you from bringing out this kind of trademarks in the market, this kind of products in the market that will make people confused, and people will start buying your thing also thinking that this is a thing from Pepsi. Do you understand? Is there any question? I didn't see that. Okay, so if there any question, I can take it later also. What is the criteria for registrability of trademarks? When I was teaching you about patents, there were three criteria of patentability. Does anybody remember? Novelty, inventive step, and industrial applicability. So these are the three things, three criteria for patentability. To get a patent, you need those three criteria to be satisfied. Here, in case of trademarks, there are again three criteria. Those are, first is distinctiveness. The first kind of requirement relates, ask them to stop. The first kind of requirement relates to the function. Okay. Relates to the function to distinguish the product or services of one enterprise from the product or services of another. Uh, just a moment. Okay, so the first one is distinctiveness. The first kind of requirement relates to the function to distinguish the products or services of one enterprise from the product or services to another. Uh, just the way I told you about Pepsi from Coke, you can change it. The second one is permissible by law. So the name should be permissible by law. It should not be deceptive or contrary to public order. So the second kind of requirement relates to the possible harmful effects of a trademark if it is a misleading character or if it violates public order or morality. So that kind of marks also are not allowed. Number three, it should be available. If it has already been taken by someone, then anyway you are not going to get it. So the third kind of requirement relates to the existence of the earlier rights of third parties which may prevent the registration of the trademark. So as I said that Pepsi is already there in the market. So if you bring out another beverage giving the same name as Pepsi, it's not going to happen because it should be available. So here in this scenario, I wanted to mention something that in regarding this availability scenario, it might sound very stupid, like this is the regular way to get it, it should be available, but this is a big thing in China. What happens in China is that there is basically nothing available to register as a trademark. Everything else has been registered as trademark. Whatever you can think of has already been registered in China, not for using it. There are some people who just registers those name as domain name or as trademark name. They will just register it so that other people, when they try to use those marks, they will have to pay these people to get those trademarks, to basically get the license from these guys. So they have to pay a lot of things. Nowadays, these things are there in India also. People are starting it. I won't recommend anybody doing like that. But in India, for last 3 4 years also, people are doing it. They are capturing all the possible names in the world, so that when people are trying to buy it, they have to buy it from you. They have to give a licensing fee to you. But I don't recommend you guys doing it. I'm just telling it. This is the story of uh, China. The availability is very difficult to satisfy. So what you can register as trademark? A product name like Apple's iPod, a service name like Amazon. As I told you, a product and a service, these things are different. Product is something, an article, a product. uh, you got it right. A service name is something. Amazon is not a product, right? Amazon is a service. They are giving you some kind of service, but that is not a product. Where something is written as Amazon, it's not like that. But Apple's iPod is a product. Something is something, some product is there, tangible product is there where it is written as iPod, right? That is Apple's iPod. So that's a product. But Amazon is not a product. This is a service. Airtel is not a product. That is a service. And then person's name, surname like Shah Rukh Khan, and recently I guess Samita Bachchan, something has happened also. You guys, if you're not there from India, Shah Rukh Khan and Amitabh Bachchan, these are big uh, movie icons in India. So Shah Rukh Khan, the name has been registered. If you ask me to register my name, I cannot do it. People don't give it because I'm not that famous. But Shah Rukh Khan has done it. His name is a trademark because some other person were using his name and making money out of it. So he registered his name so that uh, you know nobody else can misuse that name. Then abbreviation like BMW. BMW is not a word, that is an abbreviation. So like that also you can register as your trademark. Then a logo or symbol like the shoes symbol of Nike, this thing, Nike. Then tagline, KFC is finger licking good, and here in this thing, MACD is I'm loving it. These are the taglines. So just this thing, huh? It's finger licking good for KFC, or I'm loving it for MACD. These are the tagline that has also been registered by those companies. And then there are some certain options, some specific. These are called some specific trademarks. Those are not names, logo, or symbol. They are color mark. For example, Cadbury has registered their color as trademark. Then sound mark. Nokia has trademarked their tune. And then scent, smell, or olfactory mark. Flowery mask scent in Verizon store. Verizon is not there in India. I guess I think it's not there in India. It's there in the US. So the Verizon store, when you walk into that store, there will be some flowery mask scent uh, in those stores. So that scent also they have trademark. So when, if you open your store in that country and you put the same kind of smell in that store, these guys, these Verizon store guys, they can sue you for using the similar scent, because people might get confused. They might think that this is another Verizon store, right? So these things can also be trademark. Now, what you cannot register, just the way here I have told you what are the criteria for registrability, distinctiveness. So here, just the opposite thing. What you cannot register, if it is non-distinct, if it is non-distinctive, so you cannot distinguish it. If it is descriptive, please remember this term, that if the trademark is descriptive about itself, if the trademark, the name of the mark describes what the product is about, that kind of trademark you are not gonna get. I'm repeating again, if your trademark describes what is the product about, then you are not gonna get that trademark. For example, we have Apple, right? Apple iPhone, but that phone has nothing to do with an apple, right? So it doesn't at all describe the service, the product it is related to. So it should not be descriptive. Please remember, it should not be descriptive. The mark, the name of the mark should not be descriptive. Then if it is capable of causing confusion or deception in the market, then that mark will not be registered. If it is likely to hurt religious sentiments, definitely no. If it is obscene or scandalous, definitely no. So in these cases, these are the cases where you cannot register the mark as a trademark. Then what is non-use? This is also important. If the owner of the trademark, so when the mark has been registered, it is already a trademark, but it has not been used for more than 5 years and 3 months. So the mark was already registered. For example, Pepsi. These guys, they have already registered the trademark, but for some reason, they stopped using the mark for 5 years and 3 months. Then you can go and start using the mark, because in that case that will come under the non-use criteria of trademark. So anybody else can use that. So for 5 years and 3 months it has to be there. If it is only 1 year, you cannot still use it. So these are the exercise I give you, because here I have told you about this, what you cannot register, you cannot describe. It has to be capable of distinguishing one service to another. Here is the exercise for that. Type in the chat box quickly. We have only half an hour. So what do you think about this, marks? Pure water, for mineral water, if you are bringing one mineral water bottle, putting the name pure water, are you gonna get it? Then if you are putting the name 123 for calculator, are you gonna get it? If you are putting parmesan for cheese, are you gonna get it? Yes or no? Please write in the chat box. I'm waiting. Okay, this, yes ma'am. Okay, I can see these are question. I'm asking the answer for this. You write A, yes, B, yes, C, yes, or A, no, B, no, C, no, like that you write, so that I can understand. Okay, excellent. Gutti Konda Sveta. Yeah, you are right. A is no. There is a one question, I will take it later, okay? Yeah, Damodar. What is the answer? Parmesan I understand, but what is the answer? C, yes. Krishna Sai Gokul. Okay, everybody is saying C, yes. Everybody is confident about A, no. Yes, A, no. B, no. Whoever is writing B, no, you are right. Sindura Aroju. I'm sorry, I'm not able to pronounce. But B, no, you are right. Uh, A, no, everybody is right. C, no. Vempadapu Sai Venkat. Uh, yeah. So whoever has written no, 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 you are right. So as I said that this pure water, the first one everybody understood, right? If it is a descriptive mark, pure water for mineral water, so that is not going to happen. You won't get it. Then the word mark 1, 2, 3. 1, 2, 3 is very general. The number 1, 2, 3 is very general. So if you block 1, 2, 3 for your calculator, you are blocking some general terminologies, general numbers. I need to connect it to the charger. Just give me a moment. So these are very general marks. You are not going to get it. Because tomorrow somebody may come and register for 1, 2, 3, 4, 5, 6. So these things are not going to happen. And then the word permission. Uh, whoever wrote no, you are right. Because permission is a cheese name that already exists in the world. So that is also another no. I hope that is clear. Is there anything in chat? Everybody is saying A, no. Yeah, yeah. C, yes. Maybe saying C, yes is not right. Can I protect my trademark by registering it before I start it to use it? Yes, you can do it, but after that you have to start it. Otherwise, if you don't use it and for uh, 5 years and 3 months you don't use it, then your friend will use it. Right? You got my point, right? And Damodar Bhaskar? Yes, now we understood, right? Everything is no. Yes. My presentation. Okay, so the next one, next slide. Some of the example of distinctive signs are stylized word mark Google. The way the colors are presented in the mark Google, it will always be the same because they have registered it. They have registered the name like that. So G is always blue, the next G is always blue, and this O and E is red. You understand, right? Google just cannot change its color, but the color will be always similar the way they have registered it. So that's called a stylized word mark. Then I have already told you about the 3D marks of Coca-Cola bottle. That shape of that bottle, the 3D structure, you can see the cross section of the bottom part. So that is a trademark. I just told you also. So these things are uniquely identified. Then there are some distinctive signs that I was telling you about when I was giving you the example of brands, logo, and names, and all those things, right? So distinctive marks, for example, color mark. I told you about the Cadbury has already registered the color as a trademark. So the purple color of that packet, Cadbury, is a trademark for them. So if you bring out another another candy, and you put the similar color, the same color, that will cause confusion in the market. Did you get my point? So that will cause confusion in the market. So uh, they have registered their packet, the color of that packet as a trademark. So like that, whatever product Cadbury brings out in the market are all this color, this purple color. So even if you don't see the Cadbury sign, if it is flipped over or something like that, you can still understand that it's from Cadbury because of this color. Then the post-it notes, this canary yellow color of that post-it notes, that is a trademark. That color is a trademark of post-it. And then the Louis Vuitton shoe on your right hand side, the red color on the bottom of the shoe, these are only for heel, and that has got pencil heel, high heel. Those kind of shoes, you can see the color, and that is a color, registered color trademark for them. Then soundbar, Nokia. When you guys maybe nowadays nobody is using Nokia, but when Nokia was there, everybody was using it, right? Before Samsung and I think iPhone started gaining their market. So when you start the Nokia phone, there is a tone, and two hands come from both the sides, and they hold each other. One maybe one kid and one some adult person. So when they hold it, there is a sound. That sound is a sound trademark for Nokia. Then this is Netflix. The sound trademark, when you start any Netflix series, uh, this end appears like this, right? And there is a music, there is a sound, tada, like that. So that sound is a sound trademark for Netflix. Then the original Airtel ringtone, composed by A.R. Rahman. So the Airtel advertisement, when you see in TV or somewhere, there is a tune. That tune is a trademark of Airtel. So anybody else like Geo or BSNL or like other telecommunication service provider, these people, so they cannot use uh, the same tune. Do you understand? That tune is a registered trademark, registered sound mark for Airtel, the ringtone, original Airtel ringtone. So these are some of the specific example of distinctive signs. These are color mark and sound mark. These are not just the names and logo. Here I have just told you about the shoe, the Louis Vuitton shoe, how they have kept the red color just under this pencil hill. So this is another example, another exercise for you guys. If you have a weighing machine, like on your left you can see, and on the at the bottom of this weighing machine, on the four sides of the weighing machine, there are four colored squares, green squares. Can you get the color mark registered? Quickly in chat. And another is, can you register the name The Rock for your company uh, that brings bodybuilding and workout product? Okay, if you just write no ma'am, then I don't understand which one you are talking about. Dairy milk cover, dairy milk is also from Cadbury, right? So they have the right to use that color, whatever product they brings in. Your name is Kati Pina Divya Bhavani, right? So you are asking the dairy milk is also same color, but that is Cadbury, right? Okay, this question, I will take it later because there are so many questions. Uh, yes, everybody can, uh, whatever kind of product they have in their market, they can use the same color for that. The company is the same, right? So they can use the same color for all kinds of product they have. For example, they have silk, fruits and nuts, things like that, right? So they can always use this mark everywhere. Yeah, you understand, right? Okay, all these yes are for what? A is yes, no. A is no. So I will go to the slide again. Here I have told you that in this Louis Vuitton shoe, the red color is visible because that is a pencil heel shoe. So when the girl wears it, you can see the red color beneath the shoe. So there is a purpose. There is a purpose. You can understand that that is Louis Vuitton shoe, and the red color is visible when the girl is wearing the shoe. But in case of this machine, weighing machine, when the machine is being used, nobody will flip it over and see whether there is a green mark under that machine or not. So if you put green mark or red mark or whatever you want at the bottom of the machine, nobody is gonna see it when the machine is being used. So you are probably not gonna get this mark. That is my perception. Everybody is typing yes. I'm not sure what yes you are talking about. If you are saying number one is yes, no, that is no. Because you cannot see it. You have to flip it over. And what is the point of that? Why do you need some color under some weighing machine? Now you will ask me, what is the point of having one red color under that shoe? That is attractive. That looks attractive, definitely. Because all the black shoe, they will have the black button also. But when you have a black shoe, and it's generally velvety, the Louis Vuitton shoe, and the button is red one, that is attractive. So there is a purpose. But when you are using this machine, who is gonna see whether there is something, some color beneath or not, and who is gonna bother about that? No one, right? So this kind of color is probably not gonna get the trademark, but that is going to get, because that has got some appeal to the eye. So, and the next one, can you register the name Rock for your company of your bodybuilding? I'll go to the chat again. Uh, okay, all this, yes, I'm really confused. Yes is about what? So both of this question on this page, the answer is no. The first one I have already described about the color, that you cannot even see it. And next one is, there is somebody, I hope everybody knows it. There is somebody, we know him as the Rock. So if you bring out your bodybuilding product and if you give the name as Rock, because this guy came out from WWE, right? And he is now I guess he is the highest paying Hollywood actor, highest paying actor in the world. So he's very famous. His name is Dwayne Johnson. But when you bring out your bodybuilding product giving the name as Rock, so people will think that this is a product from the Rock itself. So you are not gonna get it. But if you bring out one something that is not relevant to workout product or bodybuilding product, maybe you bring out one beverage or maybe one clothesline, maybe you can keep the name as Rock because he will not be associated with that. So I hope you guys understand what I'm trying to, the point I'm trying to make. Then the term of trademark. The way I told you, the term of a patent is 20 years and it will not be extended after 20 years. The same case, trademark is a bit different because when you get the trademark, that will be first registered for 10 years. Okay, so for design also it was at first 10 years, remember, and then you can increase it by another 5 years, but that's it, 10 plus 5, that's it for design. But for trademark, what is the thing here, that trademark you can go on renewing, because why? Because trademark is the name or the brand of that company, so as long as the company is there in the market, you can use the trademark, right? So if you think that Google trademark will be there for 10 years and after that it won't be there, that cannot happen. They will be there in the market for a long time, so the trademark also should be there. So this is just the logic why the trademark will be renewed every 10 years. So you file for a trademark, you get it registered, you get the registration from your date of filing, and it is valid for 10 years. But within the 10 years you file for, you pay the renewal fee for another 10 years, then again pay the renewal fee another 10 years. Like that it can go on as long as the brand is in the market. You got it? So the trademark is renewable for an unlimited number of times for a period of 10 years. So every time for 10 years, 10 years, 10 years, you can renew it forever. So this is the difference between the term of a patent or a design right and a trademark. Trademark is continuously infinite number of times you can renew it. Patent, you just cannot renew it after 20 years. Design, you can renew it after 10 years, but just for another 5 years and not more than that. So okay, here also I have written it. A patent can be enforced for maximum of 20 years, not more than that. But a trademark can be renewed forever as long as the mark is in use. You please remember it. Then what is a well-known trademark? A mark which has become so well-known to the substantial segment of the public through its extensive and continuous use, that will be called as trademark. For example, in India, Bisleri, Toyota, Google, Horlicks, these things are very well-known and they have become well-known trademarks. So a company, there is a well-known trademark list in the trademarks website. So if you guys go there, you can see it also, and companies have the provision also that they can go and register their marks as well-known trademark also in India. So there is something called trademark classes. The way when I was talking about patents, I told you about the patent classification. So just like that, trademark classes are also there. Goods and services, I just told you about goods. You know, remember the Apple iPod, I was telling you that's a product. And then Amazon is a service, Airtel is a service, Geo or whatever. Those things are service, those are not a product. So now you will tell me Geo Mobile is a product. Yes, that is a product. But the telecommunication service is service. It's not a product. So goods can be registered under 34. There are 34 different classes. For example, class 25 is for clothing. And services are there from 35 to 45. For example, class 38 is for telecommunication. So if you can go to the trademark registry of India, you will find Airtel has registered so many things under class 38. And clothing, one clothing brand, right, like Red and Taylor or Raymond, like that, they will register their brand under class 25 for clothing brand. Okay, so there are different classes, under that you have to register for that trademark. So there is something called collective mark. For example, the CS company secretary notification, qualification logo on your right, you can see CS. So whoever is passing that exam and becoming company secretary, they can use that CS logo in front of their name, or put that in their card, in their business card, like that. And on your left you can see ICSI, that is Indian Institute of Company Secretaries of India, ICSI. So that is the logo of the organization. So that logo will be there for the organization, and the people who have passed it will get the logo CS. So you can find this logo in the visiting card or name boards of most practicing company secretaries. These things happens in India. Okay, people who are not from India, this CS thing is there in India. In your country also similar kind of things will be there. I'm just talking about the Indian Trademarks Act and collective mark, things like that. Then under section 21G of Indian Trademarks Act 1999, it has been mentioned a trademark distinguishing the goods or services of members of an association of person which is the proprietor of that mark from those of others is called collective marks. That has been mentioned under section 21G. Then certification marks, you have already seen these marks in some kind of product. For example, ISI will be there for electrical products, right? If you buy one fan or one light or something, on that packet you can see the left hand lower left, the ISI, that mark, you can see the logo over there. And then Bharat Sarkar, the government of India ag mark, that will be there for agricultural product. Then BIS hallmark is for gold ornaments, so it will be there on the gold, something gold if you are buying. So these are the government of India, they have created this kind of standard. So if the product is maintaining that standard, they will give that kind of mark to them. So FPO is for all fruit processed product, fruit like fruity, maza, things like that. Then international trademark filing statistics. This is just a statistic from WIPO database. If you guys remember, WIPO is World Intellectual Property Organization. So for you can see the trademark is the most applied IP in the world. Patent, you can see the patent number of patent filed in 2020 is 3.3 million, but number of trademarks filed in the world is 17.2 million. So you can understand the difference between patent and trademark filing. Trademark is the most filed IP in the world, and it's easier to file, right? You just bring out a company and you file for it. But if you bring out an invention, that might not be that easier to do like that. So trademark is the most used. uh, these are the top 10 IP offices where the trademarks are being filed. I'm just showing you top 5 here. So China is the highest number of trademark application, you can see over there. I was just telling you about that everything has been already registered in China. So you cannot even think about it. You see other countries like US, Iran, EU IPO is Europe, and then India. You can see the number of applications over there, and you can just see the Chinese number of applications. That's a sheer hell lot of a lot of application in China happening for trademark. Okay, so there is something called unfair competition. As I told you that it's required to maintain the fair practices in the market. That's why the trademark thing is there in the system. So companies are usually required by law to behave according to honest practices, right? It is generally accepted that it is unfair to cause confusion in the market. So I was just telling you about somebody has got Pepsi, and if you bring out something called Pepsi or Pepsi, that causes confusion. So that is unfair competition. You are not supposed to do things like that. So that may cause the confusion about the origin of that product, from where the product is coming from. So these things are called unfair competition. Then counterfeiting is uh, you create something very similar and you make people confused regarding where the product is coming from. So basically, these things are done to take over the IP rights and technology, appropriate the brand image, and you put down the image of that brand and profit from your investment made by original owner. So you think you do something really bad. So here are some example of some counterfeited product. You can see that uh, Adidas. D, you just flip it over D and make Adidas as Adidas. So if you are in a hurry, you may not be able to find it. Then you can see the MAC lipstick. In general, if you guys are using any MAC lipstick, you can see the MAC is written all very close together. But on the left, on the fake product, you can see they are, you can understand. It's not like this. MAC will be written like this. These things are like this, and it's not similar. So you can understand it's fake. But they have also written MAC. Then on your right, you can see cat caught. That's basically a Kit Kat, sorry. And it's also written have a break, have a Kit Kat, right? So they have just written the same thing and putting it as cat caught. So you not get confused. The packaging is just the same. Then for this Puma shoe or anything, they have given the Puma also on top of that, just making it Pumo. Then the Olay shampoo bottle, the bottle shape is also same here, just put replace L by K and put OK. And then, Domino's Pizza, you put a Domino Pizza. And Pizza Hut, you put at Pizza Hut. So things like that, these things are called counterfeiting, and a lot of these kind of things are happening in the world. Then trademark prosecution. Prosecution means the way how it is processed will be processed at the IP offices. So application for registration, any person claiming to be the proprietor of the trademark used or proposed to be used by him. Just now somebody was asking me, can I start registering it before I use it? Yes, if you propose to use it in future, and whose desire of registering it shall apply in writing to the registrar in the prescribed manner. Prescribed manner means there are some forms, prescribed forms, so you have to download that form and apply through that form only for your trademark. So this is the flow chart of trademark prosecution in India. If the same thing, you file it and then it will be notified, and then exam report also they will give, either it will be accepted or there will be objection. You have to satisfy those objection, otherwise it will be rejected, or you have to modify it and things like that. That is same basically for all the IP applications. So I'll be sharing this slide so you can go through it and you can see some opposition also can be there, it may not be there, like that. So what are the steps to register a trademark in India? Firstly, you select and authorize a trademark agent or attorney to represent you. It's easier because you don't have to study the act. You just pay the attorney and that guy will take care of all the things. So the trademark attorney will conduct a search whether that mark is already there in the world or not. It will cause some confusion or not. So depending on the result of the search, the trademark attorney will draft your trademark application. In case there is already some mark, similar mark in the picture in the market, so you will have to modify your mark a bit. Now, the way I told you about PCT system for international filing of patent, the same way Madrid system exists in the case of trademark. So Madrid system makes it possible to protect a mark in a large number of countries by obtaining an international registration. So here also you apply under the Madrid system and you have to select the number of countries you want to go through, you want to go to. So like PCT, you get the priority by making one single application. In Madrid system also you get the same thing. And right now, as of not right now, as of March 2020, there are 122 countries under Madrid system. So there's a hell lot of country. If you wanna go and file, protect your trademark in other countries as well, multiple countries as well, you can go through Madrid system. There are some trademark infringement cases. For example, here you can see the Adidas. They will have three this stripes on whatever they bring out, right? Their everything will have three stripes. So on the left you can see Forever 21. They started actually bringing out two stripes. So sometimes people get confused. They think like this is still Adidas, but Adidas will always be three stripes. See, look at the Forever 21 hoodie. They are using two stripes, and for the pant they are using four stripes. They're not using three steps for Adidas, but this is still called infringement because this will cause confusion in the market. So I guess Adidas was suing them, suing Forever 21 for doing like that. So this is another example of trademark infringement in India. Uh, there are two leading toothpaste brands in India. One is Pepsodent from Unilever, another is Colgate, Palmolive. The toothpaste is Colgate. So this Pepsodent, this Hindustan Unilever people, they started bringing out some advertisement that used to come in TV. I'm not sure right now it's coming or not. I don't think it's coming anymore. So they are giving similar kind of uh, just similar kind of picture. The Colgate, the guy, the way he's using some horizontal stripe here, this color is different. The Pepsodent guy is using similar thing. That guy is not able to use it, not able to use that, eat that pastry because he has some toothache or some thing like that. But because he is using Colgate and Colgate is not good. But this guy is using Pepsodent and Pepsodent is so good that this guy is very happy and he is using all pasty and he is very happy. So things like that. So this ad used to come in the TV, and then Colgate, filed some infringement, trademark infringement cases against Palmolive's, against Pepsodent, Hindustan Unilever, saying that they are bringing their brand image down. So at first, Delhi High Court said no, it's well enough, you can do it like that. Then they still started bringing out some more advertisement in the here. Also, you can see the Colgate mom and guy; they are very sad, and these people are very happy. So ultimately, it was stopped by Apple. It was stopped by Apple so that these people, you cannot bring down any other brand. You can just in some advertisement you can see that the brand name is not visible, but they are saying our brand is better than this brand, but the brand is not visible. But in this case the brand was also visible, so there was a case, a court case, and it was stopped ultimately. And this is another trademark infringement case. This is one poster from one Bollywood movie. And so there the hero in that movie was talking about one brand. He's taking the name of that brand and saying that it's not good. This was just used as a fun, but still those people Hamdard National Foundation, their product was that. So those guys filed one trademark infringement cases against the producer of this film, saying that you are not supposed to talk about our products in your film, because people, some stupid people will be there in the world who are very fond of this hero and who will think like if the hero is saying like that, definitely that's a bad product, like that. So you are not supposed to do things like that. So that was stopped ultimately. So this is the story of that. If you want to see, I just say that I will share the slides, so you want to go through the cases also. So it was ultimately stopped. So these are the example of trademark infringement cases, and thank you for joining me in today's class. Now, any question if you have? I am right here. What is the time? Okay, it's already 5. So I'm right here to take your question. Any question? Somebody is writing Vin Diesel. That guy was not Vin Diesel. He was Dwayne Johnson. But yeah, if your question is you can use Vin Diesel, no, you cannot. Okay, somebody is saying our college is not there in the list. Are you talking about WhatsApp list? So I think that will be added up. Uh, okay, as attendance, hi. Uh, can you register trademark be removed from the register? Yes, yes, it can be done. Anything you can oppose. For example, first of all, I have told you if the mark has not been used for 5 years and 3 months, so that anybody else can use it, because that will come under no use clause. So that registered trademark will move away from the registry, right? And if there are something else that the trademark was already registered, the examiner, maybe I'm not gonna comment on the examiner, but it was somehow registered, but there were some issues on it. It is hurting somebody's religious sentiment or things like that. There is one slide, right? I just showed you that on what cases you are not supposed to register that trademark. If you have those kind of criteria, so you can take it out from the registry. You can apply for the cancellation of the trademark. Anything else? Okay, people are saying thank you. Uh, how to register trademark? That is the slide. So I'll be sharing. So there is one website, Trademark Registry of India. You have to go to it. You have to log in, and then you have to download your form. Say apply trademark. You have to pay one fee also, and then you apply your trademark. You apply your uh, yeah, you apply for the registration of your trademark. So they will examine it and they will let you know whether there is any problem in your trademark or not. If there is nothing, that will be accepted, so your trademark will be registered. And if there is a problem, they will send you in the report, so you have to satisfy the clauses whatever they are saying, and then it will be registered. Okay. When the quality of the product is bad, then whom we have to complain? Okay, that is not actually under this class, because I'm talking about the product of those brands that is really good, and somebody else is using the brand name by putting some bad thing. For example, if I create just the replica of Tata Salt product and put some sand in it and start selling it, so that will be called as counterfeiting. That is something bad. But if the product is by default bad, then it's not related to trademark, so you just don't buy that product, buy something else. Yes, Sonia, you can confusion in the market, your mark will not be registered. If it is distinguishable from other marks, it will be registered. And different shapes and sizes are parts of trademark. stop? Yeah. Can any company give permission for another company to use similar trademark for some amount of time? Yes, that will be called trademark licensing. So, if these guys are giving the license to some other company that you start using this trademark for your product in your country, that will be called as trademark licensing. So these people will get money. The original trademark owner will get money. Those people will pay money. Licensee and this original guy is called licensor, right? Can a registered user restrain the third party from using identical which is not registered? Yes, that is the whole idea of trademark registration. When you have your things registered, you can stop every other third party from using a similar or identical mark, which will cause confusion in the market, right? So that is the idea of trademark registration. You can stop every other person. Okay, after that, all are thank you, ma'am. So I guess that's it for today. Uh, I hope there are no more questions, so I can wrap it up. I will share the slide with you in the WhatsApp group. Okay, so that's all for today. By now, the next class will also be about some trademark infringement, like that. Legal right and territorial right. Wait a minute. Uh, Legal right means any kind of legal right that you get. That may be a property right, one intellectual property right, any right for which you get one legal right. What is legal right? That is related to law. So if you have one patent and somebody else is infringing your right, you have some right mentioned in the Patent Act. So this is called right, your legal right. If someone else is infringing your right, so you can go to court to stop that someone. That will be called as legal right. Territorial right is something when you have that right in that territory only. Territory in that region, in that country. So when I'm saying IP rights are territorial, I mean that when you apply for patent and you get the grant in India, you have that right in India only. If someone else is making the same thing in US, you cannot stop that guy because your right is territorial. You should have filed the same thing in US also to get the right over there. Then only you can stop that guy over there. So Rabulu Ravi, I hope I'm giving you the answer. Territorial right means the right that is in that country only. Okay, IP rights are territorial. Trademark registration is compulsory or not? Better. You better register for it. Otherwise, you are using it. Tomorrow somebody else is bringing out the same thing and they have registered it. So they will stop you from using it. And you will be in a mess. So better you register it. Sonia, what is the main requirement for trademark? There is a slide. So I will share it and you can go through it. So you can know it. It has to be distinctive from all other. It should not hurt any religious sentiments, things like that. Is there in the slide. I will share it. You can just search it again. Okay, Shukriya is saying your college is not there. Your college name is Lankapalli Bullaya College. So I will convey it to my colleagues so that your college name is entered. Are you talking about the WhatsApp group? What you are talking about actually? Attendance link, you can write your college name also. Okay. Where you actually want to get it added? Supriya, are you there? Yes, attendance link, right? So you can write your college name over there. No, yes, ma'am means what? You want to get it added in the WhatsApp group? Attendance, right? You can write your name in the college name in the attendance link. There is no issue. Sonia, it depends upon all the things that if you can cross the barrier of the trademarkability criteria. So you can go through it. Group, actually, there's a WhatsApp group, but if you are talking about just the registration, just the attendance, you can write your college name in the attendance link. Virender Singh, the attendance link was already sent, right? Somebody else, if you can paste the attendance link over there so he can get it. Maybe he just joined, he was not there earlier. People know, right, when to join and when to get the attendance. Okay, then it's 5:09, so I will wrap it up. Yeah, so the attendance link is there again. You can get it. Okay, so thank you for joining me today, and bye for now.